We invited you here today to learn more about your roles as board members and to become familiarized with ethics in government, the Sunshine Law, your role as board members, the Uniform Information Practices Act, and handling complaints. We will, or you will, be hearing from the experts on the various subject matters. We assure you that the session will be very, very informative. We want to thank you for all of your time and energy that you spend serving on the various boards and on a voluntary basis on top of that. I would also like to acknowledge and thank the staff of PVL, as they are responsible for enabling you to ensure positive outcomes for your professions, vocations, and the consuming public. Again, thank you for your attendance today. I would now like to call upon our first speaker, the Governor of the State of Hawaii, the Honorable David Y. Ige.
Aloha and good morning. Welcome to the 2019 orientation, which is being hosted by the Department of Commerce and Consumer Affairs Professional and Vocational Licensing Division. I really wanted to start by thanking each and every one of you for volunteering your time to really play an important role. I do believe that citizen engagement and participation in our government is very, very important. I know that it takes time from each and every one of you to participate in these boards and commissions. So I really wanted to start by just thanking you for volunteering your time and energy to serve on the board. I've had the privilege of appointing and nominating you to the respective positions. And I really want to, on behalf of the people of Hawaii, thank you for your commitment to serve. Serving on these boards and commissions provides an opportunity for our community to engage in a wide range of government activities. It's very important that you provide input and a voice in our government. You are influencing decisions that are important to our professions, to our vocational licensing areas, and many, many other areas. You know, we need every year about approximately 300 volunteers to serve on various boards of commissions. You represent a wide range, whether representing your profession or vocation, or serving as a public member on these boards. Each and every role is different, but it's very important. It allows us to keep our profession short and sharp and in tune with changes that are happening all across our community. And I think most importantly, you represent the people of Hawaii in ensuring that we can protect the general public from bad actors, for ensuring that our professions are timely and current, and I think most importantly, so that we can find a way to move forward together. So I just really wanted to thank Director Kat Awakuni, Colón, and Deputy Director Joanne Uchida for your commitment, for engaging and talking with you, and encouraging you to volunteer on these many boards and commissions. And I just want you to know, on behalf of the people of Hawaii, I appreciate your time and energy in making our community better. Aloha and mahalo.
Good morning. I'm Kat Awakuni Colón. I'm the director of the department. It's my honor and privilege to welcome you this morning. I'd like to thank the governor for his time. Our PVL team, our Professional Vocational Licensing Division team, they were all scrambling the last few weeks trying to put together all of these details for you. We take this commitment to serve you very seriously, and so we wanted to provide as much good information as we can to help support you in your role as you seek to protect all of the various members of the public in your roles. I'd also like to thank the legislature. They allowed us to use their auditorium, and they also participated in the process of vetting you as well. Olelo, who is also a DCCA partner. And then I'd like to thank you for your commitment. I know it's a lot of time and energy that you're devoting to us and to the people that we serve. And so, again, we take that very seriously, and we are very appreciative of all of the long hours that you put in. And I don't know if everybody understands the amount of time that we really are requesting of you. Some boards are meeting multiple times a month for hours at a time, and so we really appreciate all of that time that you are giving to us. I did want to highlight a couple of things in the folders that we've given to you. There's DHRD's policy against discrimination and harassment, and also DCCA's action plan, also dealing with the same subject matter. So even though you're not employees of the state, you are going to be coming onto our premises. You are going to be interacting with each other. You are going to be interacting with our teams. And so we want to make it clear exactly what the expectations are. We would like you to treat each other with courtesy and respect. We would like you to also treat our employees and the members of the public who come before you with courtesy and respect as well. And so we hold, I guess, you to the same standards that we are going to be holding our employees. And so we wanted to make that clear by providing that information. We've also reached out to the State Department of Human Resources Development to request that they provide training for you along these lines as well. And so because it's such a large topic, we weren't able to cram it all into one morning session, but they've agreed that they will allow us to use the Employees On-Demand training system for you as well. And so we'll be providing your contact information to DHRD so that you can log on and review these on-demand training courses as well. So again, you will be very familiar with our policies and therefore more aware of what our expectations of you are in terms of, meeting that minimum level of respect and courtesy to one another and to members of the public as well. And then finally, I've kind of at a late hour included something from California's Department of Consumer Affairs. And so it's just a handout either that the team provided to you just this morning, or we're going to include in the folders as well. It's the 10 principles for highly effective board members. And so I won't read them to you, but do know that as, especially Joanna and I were reading through, a lot of this really did resonate with us, including the number one bullet point, which was protection of the public shall be the highest priority for the board members in exercising their board's licensing, regulatory, and disciplinary functions. So again, we're asking a lot of you in that we're asking you to put aside your hats as industry members or public members and really to look out for the public and for the consumers and ensure that they are protected in doing all of your work. And so again, I wanted to thank you so much for all of your time and for your attendance today. Aloha.
Hello, my name is Brian Yee. I am the Deputy Attorney General with the Attorney General's Office. This is almost like school. I see everyone in the back and all the smart kids in the front. But I was with all of you. I even see my cousin, Wes. So hello, Wes. I wanted to welcome you to state government. Welcome to state government. I've been doing this for 29 years. Before that, I was in private practice and then a law clerk at federal court. But I have to say, I really love my job. And I love it because it is, for the most part, a fulfilling experience. And I really think this can be for you, too. So thank you and welcome. There are 25 boards, I think perhaps soon to be 26, that DCCA itself covers. There are many other boards throughout the state. And boards are really important to state government because we've made the decision to include citizens in the actual decision-making process. So it's not just you provide input, you actually are part of the, you actually make the decisions on behalf of the state government. And we do that deliberately to include citizen input and involvement in this process because we don't want everything to be done by state employees. So, you know, we can't do this without you. You are important both to introduce a community voice as well as to protect the consumers. And who better to know how consumers need to be protected than both members of the public or consumers themselves, as well as members of the industry who know how everything works. As part of that thank you, I want to tell you about your defenses, immunities, and indemnification provisions that we provide. And we provide more for board members than we do for state employees. We value you even higher than we value me. First, if you are ever sued for any matter in the course and scope of your employment, the Attorney General's office provides the legal counsel. You don't have to go out and hire someone. You may. You can. You could spend your own money to do so. But we'll do a good job, and we will do it for free. Second, with respect to immunity, if you are sued, there's a very high standard for a successful lawsuit against a board or commissioner. That board or commission individually, they could perhaps sue the state of Hawaii and ask for the state's money. But if they sue you individually, they cannot successfully sue unless they can demonstrate that you acted with a malicious or improper purpose. That's a very high standard. It's more than just they made a mistake. It's more than they were, you know, they didn't know what they were doing or you know, there was no reason for what they did. They have to go beyond that and demonstrate a malicious or improper purpose. It's a difficult thing to do. I can't say it never happens, but it hasn't happened while I've been supervising the deputies, advising all of you, which leads me to the issue of you're going to be hearing from the Ethics Commission, and you will have deputy attorney generals at your deputy attorneys general at your meetings. Remember to ask them the question, and remember to listen to what they say. Because if there is a vulnerability, it probably occurs if you do something in which there is a conflict. So if you have a competitor and you decide, I'm going to take away their license because I really hate them, that creates a potential problem. Please don't do that. We have, you know, in the shades of gray, we will have people to advise you as to what is or isn't appropriate. Please feel free to ask. We are there for you. And similarly, even if you are successfully sued or if there is a settlement, the state, by law, says that we will pay for that judgment as long as you didn't act with an improper or malicious purpose. And so if there's a settlement, for example, the state will generally pay for the money because the state, if we've represented you, we've probably determined that you have not acted with a malicious or improper purpose, and so your house is safe. So it's not a complete absolute immunity, perhaps, but as long as you act within a certain very wide range of conduct, and you act basically with good faith, and I think all of you at least know what good faith means to you. I think that's something that the average individual could understand. I think whatever sacrifices you make in coming and providing your services, your house is not going to be one of them. Let me move on. The proper role of the Attorney General. So we provide a deputy at each one of your meetings. If you have a meeting, there should be a Deputy Attorney General there. Not because we know your industry, not because we know your field necessarily, although I will say some of our deputies have been working for particular boards for decades, so they have a certain reservoir of information, but we are not there to tell you how to do your job. We are there to help you and guide you through the limitations and parameters of working within state government. So we have a multiple series of roles. First of all, we're the attorney for the state. We're not the attorney for you individually, but we are the attorney for you as a member of the board. So if you as a board member have questions, we will answer them. If you want to tell me what your neighbor's doing, building their tree, and it's going across your yard, I'm not actually your attorney for that, but I mean, I might give you some advice, but I can't do that as your attorney. So I can't help you if you've had your wife had an accident. I can't help you if your neighbor is playing their radio late at night. But I can certainly help you if you want to know what the Sunshine Law requires, what ethical rules exist, what the rules and statutes for your particular industry are, which are really going to be the probable questions you're going to have for us. So we are available to answer any of those questions. We have multiple roles as well between our role as an advisor and our role as an advocate. So once you get sued, or once the board gets sued, we are the advocate. We are protecting and defending the state, and we are advocating on their behalf. Separate from that, however, we're also the advisor, and that's probably the role that you will see us most in. That is, we will be at the meeting, you'll want to know which way you should go, and you have some question about some legal question. And we will tell you what the pros and cons are, what the risks are. We might tell you alternatives that you could follow. So in that role, we're not telling you your ultimate outcome generally, although generally we're not telling you the ultimate outcome unless it is a matter of such clear legal certainty that we'll tell you, no, this you cannot do, but hopefully we'll tell you, but you could do it this other way. Or we will tell you there are two different options, option A, option B. Here are the risks of each option. Here are the legal risks of each option. And then it's up to you to decide whether those risks are appropriate to take for whatever policy reasons you deem appropriate. So it might be we're going to tell you there are two options. There's option A, option B. Option A is a little more risky. But you might think, oh, well, this is going to be more protective of consumers, so that's the position I'm going to take. And that's fine. And then if we get sued, we will be before the court, and we will tell the court adamantly that option A is perfectly fine. So that is our role as advocate versus our role as an advisor. And just to be clear, we provide you with a law, we don't provide you with policy. I told you how a number of deputies have years of experience in your field. And sometimes deputies will tell you, well, just to let you know, 10 years ago, the board had a similar issue. Here's what the board did. In doing so, we have to be careful as your attorney that we don't intrude into your space, that we don't become another board member. We are not there to be another board member. We're there to help you and to advise you. So when we're talking about issues, feel free to understand that and to ask us, well, are you telling us we have to do that as a legal question, or are you just giving us information about prior examples? Similarly, I would ask you not to ask us policy questions. So don't ask us, would it be better for the consumer if we did it this way? I mean, we might answer because we sort of like to be helpful. We like to answer questions, but it puts us in a difficult position because we can get accused, quite frankly, of being a board member and going beyond our role when all we were really trying to do is answer a question from a board member who asked us a question of perhaps a gray-shaded question, some of which was law, much of which was policy, and the answer sort of blurred that line. So we want to be helpful to you. We want to answer the questions. We generally will. But if you could also help us out by trying to ask your questions on legal issues, not policy questions, as well as not to be surprised if the deputy says, well, that's a policy question. It's up to you. I also wanted to let you know about contested case hearings and sunshine meetings. And I won't go through all the requirements. It is a very long and complicated process. It is an area that is very easy to get frustrated with. There are people there who do know. The deputy knows, your executive officer knows, but there are differences. And I just want to highlight just a couple of them. for you, just to make you aware, because one of which is who can you talk to outside of a board meeting. Now, some people will just say, I'm not talking to anyone outside of a board meeting, and that's their right. They can do so. There's nothing wrong with that. But some people want to talk to people outside of a board meeting. And the answer to that is, if it's a sunshine meeting, you can talk to people. If you're going to try to consider what rule to pass, and you have other discussions with people about their opinions of the rules, and then it's going to come eventually to the board, that's okay. You may. It's up to you. There are policy issues as to whether you're talking to only one side or not, but that's a policy issue, not a legal one. And so that's your choice as to who you want to talk to and whether you want to talk to people about sunshine issues. Different from contested case hearings. Contested case hearings are more quasi-judicial. Those are the penalty hearings. Those are the disciplinary matters. In that, it's like a judge in a courtroom. The judge in the courtroom does not talk to one side outside of the courtroom. The judge does not go and talk to even a third party outside of the courtroom. The judge doesn't talk to his friends or her friends or the media. Well, I think this, or tell me what you think as to whether or not so-and-so is guilty. Judges do not do that, and neither can you. So when you have matters that come up that are contested case hearing matters, and say primarily the disciplinary cases, and licensing as well, I strongly advise you not to do that, or at least before you do that, check with your deputy or your executive officer to make sure it is or isn't something that's appropriate. That's the kind of thing that frankly, it's a purely procedural question that can get us into trouble. And if we get into trouble, I want to get into trouble on the merits. I want to argue with someone that we're right, you're wrong, you have a misunderstanding of the law, you have misunderstood the judgment of the board. I don't want to get into, if I can, or I want to avoid as much as possible those issues of, well, the process was wrong, notice wasn't given, an improper contact was made. Those are not the kinds of questions. Those are completely avoidable problems. So I'm happy to talk about it more, and I do want to leave time for questions for many of you, but I just want to leave that with you in mind. I said you can talk to anyone about what happens about a board meeting, but I do want to put one caveat to that, and there's one major exception. That is executive sessions. So some of you may know about executive sessions. Normally board meetings are open to the public, but there are certain limited matters that can be held, discussed without the public in quote unquote executive session. And your deputy and your EO will go through some of the list of things that can be done in executive session. Some of the major ones are to discuss with your attorney the rights, liabilities, privileges, immunities, and liabilities of the board. Some of them include an evaluation of an employee, employer or officer of the state, and I believe DCCA has a separate one for the discussion of licensees. So those matters are discussed in executive session. That cannot be discussed by you to anyone outside the board meeting. I said you can talk about things in the sunshine meeting. That's an exception. So, and in part because the right or the privilege to release that information is the board's, not the individual board member. So, and I will tell you the biggest temptation is going to be where there is a disagreement. And you want to tell someone, this wasn't my fault. I thought this, so-and-so said this other thing, go blame so-and-so. You can't talk about that in executive session, about what happened in executive session. If you want to, you have to raise it to the board, you have to ask them for permission, and generally it's not given, but you can ask. But those are the kinds of things that are tempting to do. Please avoid the temptation. Again, it creates problems that are just unnecessary and avoidable. I talked to you about malicious and improper purpose, and that you're good as long as you don't have a malicious or improper purpose, and so your house is safe. The one thing, you're going to have someone coming up here to talk to you about ethics. One of the aspects of ethics are conflicts. That is, are you using your state position for a personal or private purpose? Are you making a decision in which you have a conflict of interest? I just want you to know that you are always entitled to recuse yourself from a case if you believe there is a conflict. And I want to encourage you to talk to your deputy or your executive officer if you think there is a question. It's hard to go through the myriad and universe of possibilities in which that can occur. And I'm not saying every matter in which there is some tangential relationship to you is a conflict. It is not. That would be in this state. If we have someone in the industry and there's someone else in the industry, it's impossible to avoid. So I'm not saying every touching, or it's like, oh, I do know this person, I saw their name on an agenda. That's not a conflict. But there are various grades that will get you closer and closer in toward that. I only mention it now because it's again a completely avoidable mistake, and all I want to encourage you to do is to make sure you talk to the right people when you see that issue, and just to raise this as an issue in your mind. It will be, as you do this more and more often, it will become easier and easier to recognize. It sounds difficult sometimes because we describe it in general ways, because we have this universe of possibilities, we have this very, very broad definition. But as your particular examples work out, it will be easier and easier to recognize. And after, frankly, a couple of questions, you're probably going to figure it out. So for your particular example, it's not going to be that hard. I'm only asking you, in those first two examples where you're not sure, please ask. We are happy to answer. There's no such thing as a stupid question to us. There might be a stupid answer, but we'll do our best to avoid those. With that, I will make sure that I'm available for questions and comments. So, they asked me to speak for 30 minutes, and sort of my thought was, well, it's not hard to ask me to talk for 30 minutes. It's hard to get me to stop after 30 minutes. But I do want to stop here and just make sure I answer any questions you have. Somebody ask one question that will start.
Hi, Mike Jaffe on the medical board. So my question is, during this orientation, are we going to go over the mechanics of executive portion of the meeting? Because at our meetings, it kind of flip-flops in and out. I'm not really sure who's allowed to be there, kind of the mechanics involved, so I don't speak out of place. Yeah.
I'd be happy to answer the question. Should I just answer the question?
Yeah.
Okay. So let's go through the mechanics of an executive. That's an excellent question. It's going to occur. It starts with a motion in which you describe the reason for going into executive session. I move that the board go into executive session to, and then you institute, you insert the reason, to discuss with our Deputy Attorney General the board's rights, liabilities, privileges, immunities, and liabilities, can't remember the exact term. You get a second, you get a vote by the board, you go into executive session. Who should be there? Obviously, in this particular case, it's the attorney. It may involve those other state employees. It obviously involves the attorney and all members of the board. It may include other state employees, like your executive officer, perhaps the secretary, who are there and are necessary or appropriate for that particular discussion. It should not involve any member of the public, unless that's encompassed within the executive session. Let me go through some examples. If you talk about so, and then let me distinguish from that the contested case hearing process. So the contested case hearing process, actually the public's allowed to be there as long as it doesn't violate some other privacy law. So it might seem like an executive session, but it's actually it's a different process, right? So one is a sunshine meeting, and you have an executive session to, let's say, evaluate a licensee's application, and that is then just the only people there should be the board, the attorney, and those DCCA employees who are appropriate for that discussion. Separate from that would be a contested case hearing in which someone has filed disagrees with a decision by the board, and there's a contested case hearing, and the hearing comes back before the board. If that's the case, then the meeting is generally public, but if, let's say, you're going to talk about something that's covered within a statutory exemption like mental health, alcoholism, then they can ask, I would like to close the contested case hearing to the public, and the board can absolutely and should do that. And at that point, then, it's allowed to be the board, the state employees, the attorney, and the parties to the case. Because you're not closed, because you have a contested case hearing, and you're closing it to the public, but not to the parties of the contested case hearing, because this is part of the contested case hearing. Then, separating from that is decision-making in a contested case hearing. So when you have a contested case hearing, let's suppose you closed it so that they could argue something about mental health or alcoholism. They finished that, and then you go into decision-making. Not because it's a sunshine meeting, but because it's a contested case hearing, you can have that decision-making process be done just with the board. Sort of like a three-member appellate panel on the Ninth Circuit Court of Appeals. I don't know if you were familiar with this. There are 3 judges on the Ninth Circuit for each panel. They don't have that discussion about what they should decide in public. The argument occurs in public, but their decision-making occurs in private. Your decision-making can occur in private as well. Does that see? I've given you multiple different ways to look at this because there are multiple different ways in which it occurs at a board meeting. You want to ask another question?
Who's in charge of calling the executive session? Chairman?
If you're in a sunshine meeting, it needs a motion by any board member, a second by any board member, and a vote. The chair will call the vote. And then, frankly, the practice, or what I have seen is most people don't object if someone wants to go into executive session, so then everyone votes, and it's almost always unanimous. But it doesn't have to be. You could have enough people. And then you would still need, okay, I'm going to go into the weeds. And I was thinking, let's not burden you with all of this information, but you need a majority of the votes to which the board is entitled. So you have 9 members on a board, you need 5 votes to go into executive session. If you have only 5 people who have showed up, you still need 5 votes to go into executive session. Any questions? Because I've been brilliant. Okay, well then, I think the only other thing then I wanted to make sure I let you know about is, oh, and I forgot to leave my card. I was going to put my card out in front. I will get that information out. But when you go to your how many people you've already been to your board meetings, right? Anyone not been to a board meeting yet? Okay, perfect. So you've been to your board meetings, you've met your deputy. If you need a card from the deputy, just ask. We have tons of them. We never use them. I've been 29 years. I don't think I've finished. So we're happy to give our card. We just really normally forget because unlike private, we're not trying to gin up any business. It's okay if we don't have more work. Yeah, no, we're available. You can call us. You don't have to wait for a board meeting. You certainly may raise issues before and after or during. The last thing I just wanted to tell you was the system can be complicated, and it is complicated. But there are a lot of people there to help uncomplicate it for you in any particular circumstance. So ask. Just make sure you ask. And if it seems unclear, sometimes because it's so complicated, we don't explain it well. And I apologize now if I have not explained this well to you, but I know sometimes when we're discussing, the perfect example would have been the executive session question. It's a complicated response. There are multiple different processes, and there are different ways in which you go into a confidential discussion for each process. So if we are confusing to you, or if it's just a confusing topic and you need time to think about it, and then you thought, oh, I have another question, don't think to yourself, oh, I've already asked a question, I shouldn't ask again. Ask it again. Ask it multiple times. Ask it each time. Ask it multiple times, even if in the same discussion. It's perfectly okay. We welcome it. We actually like that dialogue. If you're happy being quiet and never asking questions, I'm not criticizing it, but I just want you to know we are available for anything, any issues you may have. If there are any other questions, after saying you should ask every other question, I see that has fallen on deaf ears. Nevertheless, thank you very much and welcome to state government.